Yeah, and speaking of that sort of forward path here, we have this ruling from Benitez now. It has a 10-day stay on it, right? So you're not getting that Freedom Week situation where the law is not in effect.
Right. The state learned from their mistake the last time around and preemptively asked the judge to stay his ruling if he was going to rule against them, so that there was no lag time between the district court not staying it and the Ninth Circuit having to stay it. But the state is now in the Ninth Circuit asking them to stay his ruling while it's appealed.
Right, which is not an uncommon thing, right? That's pretty common in this sort of litigation for stays to appear on these sorts of decisions. I know that can be frustrating for a lot of people. Me too. Right. You read that the judge has found a law unconstitutional. Well, how can an unconstitutional law stay in effect? It's common because that's how the court system works. You have to go through the layers. But so, like you said, it's going to be a Ninth Circuit panel. I assume we don't know who the panel is going to be yet, right?
Well, that's something we're actually getting ready to argue about. It should be the same 3-judge panel. The en banc panel has the ability to keep it. They don't have to send it back down to the 3-judge panel, but they usually do. But in this case, they know that if they send it back to the 3-judge panel, that 3-judge panel is going to rule in our favor too, because they already ruled in our favor under Heller.
Right.
And Bruin makes it harder for states to justify a gun control law. So the en banc panel may hold on to it, but that's something we're trying to request that the court do, is send it right back to the same 3-judge panel that we won in the first time.
Interesting. So there's some strategic litigation going on here, essentially, trying to go back up the same way you did previously.
Correct. Yeah, this is basically, we've litigated this case twice. I mean, it's essentially went all the way from the district court up to the Supreme Court, now back down to the district court, back to the Ninth Circuit, and then who knows where from there. So we had to start over from the district court level and have to litigate it again. I know it's very frustrating. The courts take a long time. And in fact, when they remanded it to Judge Benitez, one of the judges said, "Why are we doing this? We know we can decide this without remanding it. We know it's just going to take 2 more years."
Right.
But some of the judges on the en banc panel or the Ninth Circuit, it used to be 2/3 Democratic president appointees, and now it's about 50-50 thanks to the Trump administration. But some of those judges want it to go slow. Yeah. Because they're hoping there'll be some kind of a change at the Supreme Court.
Yeah. Yeah. Again, with the sort of delay tactic involved with strategic litigation, judges can count numbers too, right? And they understand sort of the implications of these rulings as well, and how litigation actually plays out. And so they get stuff like this happening. And you're right. I mean, you kind of just relitigated the whole thing, because as much as Bruin changed the standard for federal courts, the idea of using a history test, a history and tradition test, was obviously around before Bruin, and Benitez put really that test in the initial Duncan ruling, right? So
yeah,
not much really changed. Yeah,
Heller specifically said interest balancing is not the right approach, not the right standard of review. But the courts twisted that. They came up with they called it something else, but it was interest balancing with a mustache. It's the same thing. You're saying the state wants to say, "Oh, we have this overwhelming public safety interest that outweighs any individual right to possess any particular type or any firearm for self-defense." That's the kind of balancing that a court can always put its thumb on the scale and come up with whatever result they want. You can always interpret public safety versus they would say there was a while there where they were trying to claim that the right to keep and bear arms only applied inside your house.
Right.
So
because of Heller,
yeah. So
because that was the specific question in Heller was about inside the home.
Right. And Heller and Bruin both dealt with firearms for self-defense. That doesn't mean the Second Amendment only covers firearms for self-defense or arms of any kind for self-defense. As I said earlier, hunting, target shooting, going to the range, getting your gun repaired, all of that, the accessories, all of that is covered. It's all ancillary activity related to the underlying right to keep and bear arms.